Okay. All right. Welcome everybody to our CE class this morning. The great debate of shall versus may. I know you've waited a long time for this. So go ahead, Joe, drop that needle.
That was a lot less exciting, wasn't it?
Joe, go ahead and drop that needle.
Let's get ready to rumble! Now, for the thousands in attendance.
For the thousands in attendance to our CE class this morning, let's get ready to rumble. All right. I know we've, boy, a lot of us have talked about this subject for years about how we, how do we handle that section of the REPC? So I'm excited to really debate this today. We're obviously joined by our own attorney, our company attorney, Mark O'Brien. Hi, Mark.
Hello.
Good morning.
Morning.
Thank you, Mark, for helping put together this content, by the way. Appreciate that.
Absolutely.
And Craig Lelis is here, and one of our outstanding brokers, and Kevin Cameron, another one of our brokers, and Mike is on, I see. And I see Chrissy, who's enjoying the good weather down in Arizona, is on. Let's see, is Kevin Larson on? No? Okay.
He's on the 13th hole.
He might be. and deservedly so. Okay. Well, guys, I hope you printed out the handout and you're ready to take some notes on this. So, really today, matter of fact, okay, actually one more kind of house cleaning item. For all of you who do not have your video on, and I'm scrolling through the pages here, there's quite a few that do not have video on. In order for us to make a case that you actually attended the class, please make sure that you answer the questions through chat so that we can, confirm that you were attending the class and not just listening in, okay? And for all of us, I mean, I would appreciate the interactiveness and your participation this morning. So, okay, all right. Without further ado, let me hit you with a couple of questions. Here's the first one. How many of you have often wondered really what would be better for your client to mark this shall or may? Have you wondered about that? Is this an issue of clarity for you, and you're certain, which is best in most cases, or are you concerned that you're not really sure how to handle that one? Likewise, and keep the answers coming. Here's another one. Have you ever been countered in an offer in which the counter included a switch of one of those, either a may to a shall or a shall to a may? I wondered sometimes, thinking through that, if the counter was made with some, I guess, some good reasoning behind it. And there are reasons for both of these answers. There's like everything we do in life, there's an exception to every rule, and there's never, ever one right answer all the time. Right, Mark?
That's correct. That's correct.
This is why we get paid the big bucks, right? To make a determination on which is best per case. So
I think it's important to point out, looking at our objectives, I think it's important to point out one of the things we're attempting to do here is somewhat, like Will said, determine a default position of kind of where we might want to, not necessarily steer clients, but where we might want to suggest that they end up. But the idea here is really to help you coach your clients and teach them and enable them to make the decision that's right for them. Because ultimately, this is their decision over shall versus may. It's not ours. But we need to be able to coach them to make the most effective decision for them. We all have, many of us have strong opinions on where they should come out. And in reading this outline, you might be able to discern where the authors can't come out. But we'll hear both sides and take from both sides to enable yourself to better coach your clients.
Well said, Mark. Thanks for that. And I am reading the chats, guys. We may not be able to get to all of those right now, but thank you for your input there. already kind of getting some answers, Mark, on those questions. You know, were you countered, and why were you countered, and that sort of thing.
I see Michael Hertz, out of town seller didn't want to be forced into mediation. I think that's a great one.
Yeah, very good. Okay, so our objectives from the top of the page here, guys, how to teach and present the benefits of mediation, I think is definitely a takeaway. There are benefits, and there are some also obviously some negative impact to mediation. We're also going to talk about how to protect our clients from costly disputes, and how to explain the costs of default. You know, some of you saw this as I was prepping this morning already, this graph. Mark, I think I'm going to start off with that graph.
Sure.
And maybe you could talk everybody through this. Guys, this is a breakdown of, take a look at the screen here. This is answer to the question of the cost of litigation. And these are the different categories that this law firm had put together: automotive, disputes, liability, property, real property resides here kind of in the center. If you can see that, okay, I'll kind of center that. Here's the breakdown in what it costs to have a lawsuit or litigation around real property. And so you want to talk that through, Mark, kind of some of these phases. And I mean, here's the dollar amounts on the left, and here's the categories.
Sure. I'd say, start off to say the two relevant ones really for us to look at are real property, obviously, and contract. Our dispute is going to fall somewhere involve both issues, obviously. These are very general numbers. They're not hard and fast for every case, but they do go through. The most important thing, I think, is the phases of litigation down at the bottom. Initiate is basically kind of your court costs, filing fees, your retainer to get an attorney on board. Discovery is your fact-finding process, which it will involve depositions and subpoenas and paying lawyers to look at those documents that are produced. I can't see the next one. Oh,
Settlement.
Settlement negotiations that, there we're talking about likely a mediation or informal settlement discussions between the attorneys and the parties. Obviously, there's cost associated with that. Pre-trial, getting ready to go to trial, and then the actual trial, days spent in court, expert witnesses, and all the costs associated with actually going to trial and spending the time and paying the lawyers to be there. And then post disposition is really just kind of the wrap up, getting the putting the case to bed, so to speak. So in all those steps, your clients are going to incur a great deal of cost if you go down the litigation route. Could it be far less than $66,000, $91,000? Of course. If the dollar amounts at dispute aren't that significant, or the issues aren't that complex, of course it can be less. Can it be a lot more? Of course. But these are good kind of general numbers that someone came up with, and I think they're a fair representation of general costs of average litigation.
Great, Mark, thanks. I think that's, I think a lot of the brokers, we do a leadership, I'm gonna pull up the next slide here, guys, but we have a legal meeting we do monthly, which we take a look at some of the issues that we're dealing with as a brokerage. And fortunately, they're not a lot. We do a really good job of frankly doing the deal doctoring, and our agents are very good at putting together agreements. So we are managing a very small segment of what could happen. And I can't help but think that if you're in the business, for decades, and many of you are, and you deal with dozens of clients every year, what's going to happen is sometime at some year, at some point, this may become, really material, and that you're going to have to deal with. Not all of our transactions are potential litigating issues, or do the principals get involved there? Sometimes we do get, the target on us. And of course, we do everything we can to avoid that and minimize that. Let's jump into the handout, guys, and make sure we answer a couple of these as we're getting a running start on this. I'll go back to sharing the screen. So grab your handout and let's make sure that we fill out, yeah, I'm gonna grab, let's see, just move this up. Okay. Okay, so the first section here is we're talking about section 16 first before we get into 15, the shall and may section of the REPC. But let's make sure we're all clear on what are the options that the REPC gives the party as default or in breach of their agreement, and make sure we've got these 1, 2, and 3. You want to take a stab at what the first answer is. What's A in 16? Section 16, what are the remedies for default? What are the options that they may choose? What's the first thing there? Go ahead and type it in. What is the first option?
Take the earnest money.
Yeah, so thanks, Kev. So our first one is cancel REPC, keep earnest money. So go ahead and write that one in. Cancel, I mean, just, simple, simple way to describe A is cancel the REPC and keep the earnest money. Of course, we know if this is on the seller side, if they're in breach and the buyer wants to cancel, then the seller matches that deposit, right? Okay. All right. What's number 2? What's number 2? What's the second option?
Jennifer Maloney's got it there.
Yeah, maintain the deposit, and then and basically this is litigation, so lawsuit, right? So earnest money in number 2 stays in the trust account, and then there's a lawsuit. Do I need to, Mark? Why is, or anybody, why is the earnest money left in the trust account? Why is the earnest money still left there? It's probably an obvious answer, but in case you didn't know, why does the money stay in the trust account if there's a lawsuit? Anybody? Mark, do you want to just take that one?
Sure, because that's not a remedy that a party elected. The remedy that the party is electing is to attempt to obtain specific performance, a specific performance order. The remedy is not the release of the earnest money. They're going for a different remedy. So while the remedy they're seeking is pending, the earnest money stays put in trust.
Yeah, so sometimes the earnest money is not enough to cover the damage.
But
sure.
And
so they do want a performance, maybe, so the lawsuit could be a performance to, force a signature, a sign, to execute the closing. It could be that there's damages to the property or to the transaction that are in excess of the earnest money deposit. So that's number 2. Yeah.
In 43 years, I've only seen that happen once.
Yeah, where it stays there. Yeah. And then
well, and the performance actually worked, and they forced the buyer to close.
Interesting. Yeah, I've heard many times that suits for performance are really tough.
They're particularly tough against a seller. We're a very property friendly state, so to enforce a seller to actually part ways with the property, it would take some pretty egregious conduct on the part of the seller, and a pretty clear-cut case, because damages would otherwise suffice.
Yeah. Number 3, what's the third option here? Of course, we're talking about this paragraph, guys, right here, 16. So what's the third answer in this options for defaulting parties to remedy? So if we come down and look at that in 15, there's kind of I'll call it a legal catch-all. Here it is right here. Any other remedies available at law? Mark, what comes to mind there? I mean, if we're not taking the earnest money or not having a lawsuit and the earnest money stays, what's the other remedies?
Well, maybe the damages are so significant that the party may choose they don't want the property anymore. They want damages and to walk away from this particular property.
And the earnest,
like you say, it is a legal catch-all.
And the earnest money is not enough.
Right, the earnest money is not enough, so they want damages. They don't want to be limited in their claim to a specific performance claim. They want a damages claim or some other claims. Maybe there's a disparagement or some sort of other issue that they want addressed by a court.
But remember, you are releasing that earnest money. So, like say there's $10,000 earnest money and you think you got a $50,000 claim and you don't want the 10,000, you're giving up that 10,000 in hopes that you get that 50,000. You may walk out of court and only get 5,000. I've seen that happen.
Sure.
Where
Absolutely.
the earnest money would have been a better option.
Mhm.
The interesting thing about C, to Kevin's point, is look at the first requirement: return the earnest money deposit. See, the other one is it's staying in trust, and then there's a lawsuit. This is returning it.
I tell you, if any of you have, those who haven't taken Lance's earnest money class, 1 hour CE, you need to take it. He has an amazing argument about earnest money and why it needs to be what it is for both sides of the transaction. Sometimes, it's just really spells this out so you don't get caught in this kind of a situation where the earnest money will resolve the issue. That's what you really want to think about when you're making an offer and when you're a seller accepting an offer.
Well, and we should probably mention that the buyer and the seller have pretty much pre-agreed that the earnest money would cover liquidated damages. And so if your client decides to sue, they need to know that for additional damages, they need to know that it's an uphill climb. It has to be provable damages, not just some vague idea of being off the market for a couple of weeks.
Yeah, Craig, I was going to turn to that section, guys. I don't have the REPC pulled up right here handy. But remember, when it's a financing issue and 8.3 was marked as a condition, remember we talked about this before, then all of that language in section 8 applies. And if the buyer doesn't get financing, that's not something that's a lawsuit. The earnest money has already been predetermined to be the damages. So that's not going to be governed by default. So the lack of getting a loan is not a default. It's actually governed by the 8.3 section, which the only remedy for that is to take the earnest money. Thanks for bringing that up, Craig. Okay.
You see John Lucky's remark there? He just talked about if there's a moving expenses and they were high, would you select C? Well, they'd have to be, that's why earnest money is so important, because moving expenses can't be more than what, $5,000 or $6,000 or $7,000. And if your earnest money is $500, yeah, you might want to sue the guy, but still you're going to court, you're taking a chance.
When we get pay close attention to this next segment. This comes up a lot. When you're filling out a REPC and it comes to the part of the earnest money, and everyone always says something simple like, well, what should it be? And then and we kind of go fast through it, right? We probably come up with some idea of 1% or something that's traditional, and everyone moves forward. But I think that there should be a question attached to this that says, what would your damages be if the other party defaulted? And think about that as you're accepting an offer as a listing agent. We should come to section 16 and explain where the earnest money comes in. To Kevin's point, and a lot about what Lance's class is about is that the earnest money should be enough to cover the damages. But we don't know what the damages are unless we ask. And every case is a little different. So make sure that you're asking the question, what happens if the other party defaults? You're likely to only want to retain the earnest money, okay, is option A here. You're probably likely to do that, and that's usually the better route because litigation costs are expensive and a lawsuit is expensive. And then that's where everyone gets frustrated because the earnest money was not enough to cover the expenses. And if we backed it up, perhaps the question was not posed in the beginning. What are the damages if the other party defaults? Answer that. And I think, John, that's kind of where those things should come up, right? And then we can adjust the earnest money. And if you're on the listing side, that's where the counter comes in because the seller knows what their damages may be if the buyer defaults. Okay.
Allison, did you see Allison's remark? She said that's when someone is offering to put the earnest money in a title company, you need to counter that, get it in a real estate trust account. because we lose total control of it at that point.
Yeah, how many of you, I'm assuming a lot of you understand this, but just to review, what's the difference in having the earnest money at title and earnest money at a real estate brokerage? What's the difference? Think about that for a second. Anybody want to weigh in? Who hasn't? Mike, do you want to talk about this one? The difference in title, earnest money held at a title company versus earnest money held in our trust account. What's the difference?
Yeah.
Most of these people are answering that right. Yeah.
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 Very good, guys. Keep the answers coming so we know you're participating.
Yeah. I think that the biggest thing is to have, I'm assuming you mean me when you say Mike.
I do. Yes, Mike.
Okay, good. The biggest difference is that your broker can go contest earnest money, and the other brokerage should not make any moves with that earnest money until those things are resolved. The other brokerage, as well as us, can actually make decisions about whether or not to release that earnest money based on what we find. So the title company will never weigh in on those decisions and will only wait until both parties sign off on the release. The title company doesn't care what's going on, and they don't want to know. So if there's going to be any real problem that can be resolved, if there's clear default on one party or the other, the brokerage can make a decision to release the earnest money. That's the biggest difference, and it's huge. When it matters, it's a big deal.
Yeah, we've got conflicting language, frankly. The REPC says to be released without further, authorization, right? That's littered throughout the REPC, but the title company is going to require another authorization. And so you can imagine if you get into dispute with somebody over the earnest money, the party that's going to lose the money just refuses to sign. And then the money sits in the title company. This is why we have an addendum to allow the buyer's earnest money to be posited in a seller's brokerage trust account, right? So that can be a deeper dive into another class, but that's a benefit to our seller clients, that if the buyer defaults and it's clear in the contract, our brokers can authorize the release of that earnest money, and it goes to the party that is in line with the contract. So the title company doesn't, like to Mike's point, that doesn't care about the contract. They care about the contract, but they're not governed by that. They're governed by the insurance commission and not by real estate contracts of the parties. So we'll save that deeper dive for another day, but I think it kind of relates to what we're doing with here with this minimizing costs, and earnest money is clearly the top choice. When we have a remedy for default, it usually goes to earnest money. So it's really important to understand how all that works when you're filling out an offer and when you're looking at one from the listing side. All right, guys. Okay, thanks. I'm going to turn the channel. Let's go down to and understand now. We're going to talk about our section 15 and dive into this. So, and we're talking about the mediation section in the handout here. So I'm just going to read through this, guys, so follow along with me. In a dispute relating to the REPC arising prior to or after closing, shall or may, at the option of the parties, first, I think I'd highlight that, by the way, the first, that's material, be submitted to mediation. Mediation is a process in which the parties meet with an impartial person who helps resolve the dispute informally and confidentially. Mediators cannot impose binding decisions. That would be what? Arbitration. The parties to the dispute must agree before any settlement is binding. So what I see here, guys, this is a new agreement. That's what that is. That's this line. It's a new contract, a new agreement. The parties will jointly appoint an acceptable mediator to share equally in the cost. I would highlight that, cost. There is a cost to mediation. If mediation fails, the other procedures and remedies available under the REPC shall apply. Okay, so that's remember, we go back to default and laws. Our laws governing the default that we just talked about in 16 here. Nothing in 15 prohibits any party from seeking emergency legal equitable relief pending mediation. So if damages are racking up quickly and mediation is causing a delay, there is a provision here to address something that's an emergency legal relief. And this provision will survive closing. Okay, so that's the section. So, a lot of times we just don't, where are we on this? Should we make this a requirement to first mediate? And that could come back to bite us. There is a cost to mediation. Or should we just say, well, you know what? Why don't we just have the option and we'll consider it if something comes up? Okay, so that's the meat of it. Go to your handout, guys.
Hey, Will,
Yeah.
go back to the last sentence again.
Yeah.
And just explain that a little better. Mark can. What does
Sure.
emergency legal or equitable relief mean?
Well, similar to what Will said, if damages are racking up, if the roof is leaking and there's a dispute over, who's responsible or whether or not to close, and the parties have checked shall and they're going to mediation, well, if mediation's 3 weeks out, someone needs to go to court and have a determination of who's responsible for those costs now.
So basically, you're going to skip mediation and go right to court.
You're going to skip mediation as to the circumstances or the claims requiring some sort of emergency relief.
For any emergency situation that might be going on,
Right.
like the roof is caving in.
Exactly.
Gotcha. Okay.
So that's kind of a nice addition to, because if we go back to that section, look, it says you've got to go to mediation first, unless that there's something that's an emergency, and so I think that that's a good, counterbalance to this hard, fast. It's got to be submitted to mediation. If we come back up into this section, which Mark and I put together, Mark, is there something, I've got a few things I want to pull out here that I think everyone should highlight. But particularly right here, there is often not a winner or a loser in mediation. So I think I'd highlight that, guys. And depending on what the case is, in litigation, there can be a kind of an all or nothing. You win or you lose, right? But in mediation, there's really not a winner or a loser. What is it? So it can be, where's our word? Yeah, it's a compromise. It's a settlement.
Right. So
it's kind of like, yeah, thanks, Courtney, Debbie. Yeah, you're compromising, you're settling. Hey, look, some people don't want that. They want all of it or none of it. They feel like there's no concession whatsoever. And so, they look at mediation as kind of a in the way option. I'm not really, as you can tell, I don't know what your expectations were. A lot of I've talked about this in coaching classes in the past, and maybe you were expecting Will to be, all in on all these answers. I think what we really want our agents to be is thinking for themselves with each transaction, because each are so different. I suppose at the end of this, Mark, we're probably going to make a determination on what's mostly the correct answer most of the time. But I think it's important, guys, that you understand the benefits of mediation and the pitfalls to mediation. Okay. I think that's the higher level of professional here, is that, we're not robotic and we're not stuck in concrete on these answers. That in other words, we look at what the particulars are for the transaction. We ask good questions, and then we can help counsel on whether or not we should be marking, the shall or the may. Okay. So I think that's the points I want to pull out. Anything else, Mark, I might be missing in here that you think is?
No, I think there's some important words that recognizing that mediation is a negotiation. There is this neutral mediator. He's not there to make a decision. He or she is not there to make a binding decision for the parties. That person is there to narrow the issues, to find common ground, to facilitate discussions, to lead to a compromise, to lead to what is hopefully a win-win situation. And presumably it is a win-win situation, because The outcome of a successful mediation is an agreement where both parties sign and they agree to move forward with the terms of that agreement. So yeah, this is really the main, 9 times out of 10, the result of a successful mediation is a win-win scenario. Whereas if you get to arbitration or litigation, there generally is a winner or loser. So that's one of the pros to mediation, is that both parties can take away something while both parties are giving away something, is typically the way it happens.
Yeah.
And that's compromise, as many of you have said.
Yeah, and just please keep in mind too, cost. Maybe I'd write that in here. That's why we started off with that graph, guys. We're managing, potentially a very expensive litigation process. Okay, and I know we're going to get into small claims court in a minute, but remember that there's cost issues. Okay, so the other side to the mediation piece, if we're not mediating, that means we're litigating. Let's be clear. Okay, if we're not mediating, you're getting an attorney, and if you get an attorney, there's going to be costs. And I have often heard that, well, it doesn't. I've heard arguments that, well, it's so small it doesn't matter. Well, if the outcome doesn't matter, then I don't know that it matters which one you choose if it doesn't matter. But my experience is when people get in these situations, it sure matters to them. They are really, really heightened in their emotions. Unfortunately, we're trying to be a calming, influence in these cases to try to get the, calmer heads to prevail. And mediation at least provides a sense of closure and an event that can put a button on it and everyone moves on with life without having litigation costs. But there are downsides to it. So let's keep that in mind. The other piece here in arbitration, hey, Mark, I know I didn't answer this. And brokers, please weigh in. Kev, Craig, Mike, have we ever had a case against buyer seller that they opted for an arbitration? Or Mark, are you aware of? I don't know that I've ever heard of an arbitration in a principal to principal.
I'm not aware of a case.
Arbitration?
Yeah, in an arbitration.
I think over the years, I've seen a lot of it because it used to be an option. It's just not the option they give anymore. Way back.
Yeah.
Isn't that right, Craig? Back in the early days, it was arbitration.
Oh, I don't know in the early 1900s, Kev, that any of us have any memory of the early 1900s.
Yeah, well, yeah, I do. So there you go. No, Craig, arbitration was, we used to give them, in fact, it was Arbitrators of America was the company that the UAR said we should use. And
usually they were retired judges.
Yeah.
And it was pretty expensive, and the outcome was binding. Unlike mediation, the outcome was binding.
Cheaper than court, but not cheaper than mediation. But it was a binding decision, absolutely.
So where do we see arbitration a lot is we see this, guys, when we're debating commissions. And this is governed by our board of realtors, our standards of practice, the procuring cause, issues. Matter of fact, I probably have just handy behind me here. Yes, I do. Here, I'll show you a visual just so you guys can see this. Let's stop sharing. But arbitration, the arbitration manual, this is how we do an arbitration and deal with arbitration on the board level. I think that there's 137 pages to this. And anytime every time a realtor joins the association, they already agree that this is how we'd handle a dispute over commission. So that's where we see arbitration in our business a lot. Matter of fact, there's another booklet too. I forgot. This is how, if you're on the panel to decide the arbitration, these are the rules if you're on the panel. So that's just to deal with a commission dispute. And Kevin, Cameron, and I had a pretty large arbitration issue last year, didn't we, Kev?
Huge.
one of our great agents, and we did prevail.
It was over $50,000.
Yeah, and that process again was a great university of education for all of us involved. We did choose to have an attorney present. By the way, Mark, I sure wish you were around then. It would have turned out probably better and less stressful. But nevertheless, we did go through the process, and we did prevail. The arbitration is an interesting way to handle these disputes, but it's again, what is it? What if we didn't have arbitration? We'd be suing each other for disputes over commission. So it's a much better way to go about a dispute there. But I don't know that I see that very often in a principle to principle. So let's go back to our handout and get to litigation. Okay, yeah, this piece here. Mark, just take us through kind of how do you just, litigation, lawsuit, take everybody through what litigation is, courtroom, that sort of thing.
Sure. Well, litigation, different from mediation and arbitration. Mediation and arbitration are outside of the courtroom. They're more informal. There can be confidentiality associated with them because of, for various reasons. Oftentimes you see complex commercial disputes between companies. They wind up in mediation or arbitration because they want to keep the matters confidential, whether there be pricing disputes or things of that nature that they don't want to be aired in a public courtroom. Litigation is that venue. It's a public courtroom. There is no confidentiality. You can walk in, anyone from the public can walk into the courtroom, assuming there's space. There's significant costs involved. There's attorneys involved, definitely at this point. There can be attorneys involved at every level. Mediation, there often will be. Arbitration, there will be. And litigation, there certainly are. So the process, obviously retaining counsel and then going through the discovery process and all the costs we talked about earlier, the cost of discovery, the cost of court fees, filing fees, the costs of getting experts lined up, taking depositions, your costs quickly accumulate. And this all culminates in an actual trial, either before a judge typically or a jury, depending on the state, the claim, the nature of the claim. The result of litigation, as you know, is an award, a final court order where the judge determines a winner or a loser. And it's not necessarily a winner or a loser on all the issues. A party may win on some issues and lose on some issues. And at the end of the day, under Section 17 of our REPC, the judge has the discretion, the ability to award attorney's fees to what the judge determines is the prevailing party. And some of you heard Will and I discussing prior to beginning this. The judge has some latitude, some discretion in determining who that prevailing party is in terms of awarding attorney's fees. Attorney's fees can only be awarded typically as a matter of statute or as a matter of contractual agreement between the parties. So a judge has to be able to look and see that the parties have agreed, or statutorily one party is entitled to attorney's fees. But there's some discretion involved there.
Mark, you and I too, we were talking about evidence and in courtroom, what evidence is allowed. And this, we're kind of talking in simple terms here about mediation's informal. Right. But in court, it has rules of evidence.
Sure.
I'll tell you what, guys, it just makes me nervous. If we jump to the litigation as the solution, and that's going to be just simple. It makes me nervous, because if we're going to go into an environment, small claims court or not, we've got rules in the courtroom that a lay person is not going to know. And so they're likely to then go with the attorney, and now we get costs increasing, right? Mm-hmm. So
the thing about mediation too, Will, it's your emotions can come out. What you heard, what you thought you heard, is all part of the discussion in court. That means nothing. Absolutely nothing. It's strictly evidence. Yeah, it's just a better place to talk it out. And that's why mediation is a great way to go in almost everything, because you can just say your piece, and most people just want to say their piece.
Yeah,
That's what they really want to do.
That's an important aspect of mediation. Is it enables the parties to be heard, and oftentimes that's all that the parties want, is an opportunity to be heard by a neutral person. And many times mediation is the first time that the actual buyer seller parties are speaking.
Exactly.
Most conversation happens between the agents. So having that opportunity to hear the other side's emotions, hear what's driving them, that can often lead to a settlement. And that's one of the many benefits of mediation. It's just an opportunity to be heard.
Yeah, that's a very good point, Kev and Mark. I think that, the ones I've dealt with, I think people are hurt. They get, their emotions are heightened, and they just need closure to it. And they want to make sure that what happened to them, everyone else understands. Right. And they're not alone, and they're not isolated. They want the agent to know, they want the broker to know, they want the other party to know, they want that agent on the other side to know. They want to get it out, and they think they've been wronged. And I'm going to go through a scenario really quickly to give you a story to this, and then I think we're going to just wrap it up in about 10 minutes.
But the question still prevails is, what would you choose, shall or may?
We're going to wait for that at the very end, Kev.
Well, you and I are going to role play too, so get ready.
Okay, great. So we had this was, some of you know this as the Christmas Eve mediation. So I had a seller, Kev, Cam, you know this one well. So if I missed
this is the one we're gonna role play too.
Oh, is it? Okay. So because it has some thorns in it on either side of the issue. Okay, so here we have a seller who lived in a property for 20 plus years. He sold the property. He got real friendly with the buyer, walked him around. Everything was just beautiful. It was a heavenly transaction. They made good friends with them. Life was good. The buyer moves into the property and starts having some problems. There's a home inspection that happened. Here's what we get. First of all, it starts off with a backed up sewer line. So the camera goes down the line, and sure enough, the old trees and holiday, the roots had gotten down into there and just wrecked the sewer line. It turns out that the home inspector had come in and asked the seller if they should send a camera down the line. This was just one of the issues. Should we send a camera down the line? And the seller, under testimony, this is the quote from the inspector, that seller told that contractor, "Don't you dare send a camera down that line. I don't want to know what's down there." And so he didn't. He tells the buyer that he solved the problem of the slow draining tub by putting in a new lateral line. And see, it's brand new. The lateral line exists inside the house. Well, that certainly didn't solve the problem, because we've got roots in there, and the seller, I think he knew and didn't want to know, kind of thing. Then so it's $16,000 to dig up that line that goes under concrete, a sidewalk, and some other things to replace the line and put that in there. So that's the first claim for damage, is $16,000, that the seller misrepresented the condition of the property. They knew about it, and now the buyer wants 16 grand. Well, it goes on. The seller said he would fix a deck and the framing of the deck. And the seller said didn't need any repair. Well, we had some evidence and some pictures of, and Kev, if I get this wrong, weigh in, but the seller had taken some good new wood and taken a screw and gone through rotting wood where the screw actually recessed into the rotting wood and put this new board in, and then said, "There's no rotting to the deck." That's really damaging to our seller, who said they had no knowledge of the rotting of the deck. And here I have him fixing something. Okay. There ended up being, I think, didn't we start off at $80,000, Kev?
$80,000 was the claim, but tell them what box was checked.
It was mediation. Was it shall or may? I don't even remember.
It was shall. It was shall.
It was shall. Okay, so here we are at mediation. We've got.
Now, hold on a second. You're missing
Okay.
the most important part.
Okay.
Of the stay or mail argument.
Okay.
So now we'll role play. I'm the seller.
Yeah.
You're the buyer.
Okay.
You've discovered all this.
Yeah.
And you call me and say,
Yeah.
you know, I've got an $80,000 problem here and we need to go to mediation. So let's start with that. You're the buyer.
I'm the buyer.
You're the buyer. You're talking to me. I'm the seller.
Okay. Well, you know, they both had attorneys, right?
Well, they didn't have them then. Not in the beginning. So you came in at the end of this.
Okay. Well, okay. The story goes, the seller says basically pound sand. I'm not giving you $80,000. There's nothing.
Well,
wrong
he only
with
said
that.
on pound sound, I'm not giving you $80,000. What he also said was, I'm not going to mediation.
Yeah.
And the
seller-
buyer said, well, you agreed to go to mediation.
Yeah, that's right.
I don't care. I'm not going.
Yeah.
Yeah, but you signed here on the contract that you said you'd go to mediation. I don't care. I'm not going.
Yeah.
I mean, this thing went off. This was not a week problem. This was over a year.
Oh yeah.
He said, I am not going to mediation. And so what was the only option the buyer had at this point? Now there's no issues of leaking anything at this point. And so they hired an attorney. The attorney took the seller to court. And he had to show up at court because he got subpoenaed. And they go to court and the seller says, you know, the judge says, you agreed to mediation. And so you guys need to mediate. So the buyer had to pay for attorney to go to court to force him to mediation. Now, if he would have checked May and the guy said no, he just sues him right there on the spot. And they had a lawyer hired. And so, but this, because they had checked shell in this particular situation, I am all for mediation. Trust me, I would check, my opinion, I would check May every time, not every time, but most every time. And I would always try to go to mediation. But when the seller says, I'm not going to mediation and you can't make me, oh, the heck I can't. And I would force him into a mediation situation because that's what the judge is going to say when he reads the REPC. You guys agreed to mediation and I expect you to read to mediation or you'll be in contempt. So anyway, now they go to mediation and I made Will.
Yeah, he makes me go.
Make Will go to the.
And Kev, we call this dealing cards, you guys. Okay, Kevin
dealt him that card, and it was an 8-hour day.
Yeah. Oh, but that's not what Kevin said. He goes, "Oh, I'm sure it'll be resolved pretty quickly. It's just a mediation will last about an hour."
Well, if I would have gone, probably would have, but I forgot Will was going, so that was why it went for 8 hours. Anyway, bottom line is this, though. This was a great outcome, and Will did an amazing job. And the mediator was an ex-judge, retired judge. And Will was there for one reason. He's very careful because he's not representing our client. He's there to represent the rules and regulations and what the REPC meant. And that's what he explained in each situation. So they started at 80,000. Keep in mind, it was a $16,000 bill just to begin with.
Yeah.
What do you think Will worked out in the mediation? How much do you think the settlement was? Everybody chat. I'm anxious to know. Go ahead, Will.
So, that's a good tease there. Yeah, put in an amount. What do you think we actually settled for? Because there was a settlement. There was an amount paid.
80,000 was the ask.
Yeah. By the way, let me tell you another fact, just because I think it's important. There was the back bedroom never cooled off very well. And the seller said, well, I bought a new air conditioning unit.
Right. I forgot.
That was okay. Well, guess what? The buyer said, you know what? It doesn't cool off very well. They called an HVAC guy. That HVAC guy who came in was the same HVAC guy who was there with the seller 8 months ago, who gave him a bid to repair the problem. And it wasn't a new unit. Yeah. So that was, again, a third issue that was very damaging to our seller. It was the same contractor. Like, how bad is your luck? You know what I mean? Like, it was that bad. That it was the same, busted.
You
right?
You want to know the beauty of mediation? What was the settlement? I love everybody's throwing numbers all over the place.
Before you say, let's just talk. Okay, there's a lot of information here, but hang on to this one. The reason we got to the settlement we did, because there's a moment there where I know the judge walks back in. Dude, this is 3 o'clock in the afternoon. We've already had sandwiches, right? To keep us there. They brought sandwiches in to keep us there in this small conference room, smaller than my office with no window, right? Okay. So he says, so before the judge walks in, the attorney is in there talking to the seller, and he says, I can defend you if we go to trial. He goes, but just so you know, I'll make up a name here, Steve, if we go to trial, I need $15,000 just to prepare you to go to trial. Just so you know that. Okay. In walks the judge. The judge has just been talking to the buyer, and the buyer, I'm fast forwarding so many kind of cool details, but what do you think we settled for?
There's a lot of numbers out there. Bottom line, $10,000.
I thought it was 15.
No, it was 10.
Maybe I added at the
$10,000.
cost because guys,
But they still had legal, they still both brought a lawyer. So they
They
still
had to
had the
pay-
legal cost for 8 hours that day, which wasn't cheap.
yeah, we went from 80 to 15. We were in a mediation. That's the good side of it. The bad side of it, to Kevin's point, they had to force the mediation through a court, forced in court to have mediation. Okay, we saved a lot of money in not going to trial, but they also had to pay for the mediator. And guess how much the mediator was? $3.75 an hour per side. Okay,
So it
wait.
wasn't cheap.
And then they had to pay for their attorneys.
Yeah.
And how
it
much
was
were
a-
yeah,
it's
the
an
attorney.
expensive day.
I think that's why I remembered the 15,000 because
Exactly. I was
seller-
going to say that, Will. That before you came up with 15. You thought it cost that buyer or seller about $15,000. Yeah.
All right, I'm going to give you what I think. I think we're kind of mostly on the same page here, but I want to be clear. Mark and I have been debating this also on what should the direction be. I mean, so what do we do here? And Mark, please help me if I get this wrong or we need to add something. First of all, I think you need to ask the client. It's their decision. Mark talked about that right off the bat. This is not an agent decision. There's issues that weigh into this, and you just need to understand the difference in the two options. Okay. And by the way, there's an exception to every rule. Okay. Which brings me to my next point. I think what we're doing here is we're weighing the odds. We're picking one that is mostly best, but it's not always best. Okay. So matter of fact, Mark, why don't you go ahead and you be the voice on what would you like our agents or our principals to do and our agents to help them choose to do when it comes to shall or may? Should most of our transactions be in the shall category or most of them be in our may category? What do you think?
I think I'll go back to my original statement, which was this is really the client's decision, and we have to help them make that decision. In my opinion, most of the time, and I won't give you a percentage, but most of the time, I would say shall is probably going to serve the needs of most disputes, or in the event of most disputes. I think most clients will want to, because of the many pros, avoid litigation and have an opportunity to go and be heard by a neutral party and compromise and have an agreed upon solution. As you say, there are many exceptions. Michael Hurd raised a perfect one that I've dealt with personally, an out-of-town seller. You have to take into consideration the facts and circumstances at the time of going under contract. And if your seller or your buyer, is in Singapore and you don't want to force them to fly to Park City or Salt Lake City for a $10,000 mediation, you should know that up front. You should have that fact and circumstance in your mind when you're counseling your client and be able to explain, this is what this means. This means that you will have to come to mediate, or the opposing party, the seller, can drag you into court to force you to mediate. So it's really you have to understand the facts and circumstances of your scenario. You have to allow the client to make the decision, but I am one who will defer to shall, because I like to give the parties an opportunity to be heard, to have an agreement that they both sign, as opposed to going to the cost, expense, and time involved with litigation or arbitration.
There's also another important point here. Our buyer broker agreements and our listing agreements, when we're the principal, you know, in a transaction, we've also opted to have mediation to be the preferred method. Again, it's not going to be the perfect scenario every time, but we have put that in there when we're the principal. If we get sideways with our own client, then we would rather have them mediate than litigate. And I think that transcends over to what we're trying to coach our clients on. Mediation. Look, well, you know what we don't want in real estate? We don't want the public to perceive a real estate transaction is so dangerous that they avoid real estate transactions because they're afraid and fearful of a transaction's cost of litigating. So we don't want that. As an industry, we want to portray a protection to our clients in a buyer and seller. So, okay, guys, look, I promised you we would end on time. Our time is up. Go ahead and if you've got some good takeaways, put them in the chat so I know that you are attending all the way up until the end. We'll call this our final question. Just give me your takeaway. You know, what you learned from this that was beneficial. You know how we really solve a lot of these problems? You call your broker. You know, you call Kevin Larson, you call Kevin Cameron, Craig, Lance, Mike, Sharon. I mean, these are excellent veteran, very experienced brokers who can help us, avoid these problems. If it gets escalated, we're so fortunate to have Mark O'Brien now to bounce things off of and get some guidance here. And so, you know, use our resources and we can take care of our clients better. I'm always trying to be a voice to raise the level of professionalism and make my world like I want it. And I know we're all better off if we study these things better and get on a higher level, which is what I think the grand takeaway today is there's not always an answer to one or the other. The best answer is to ask the client and to understand how to teach and educate them on the choices. And then
Rick Shan said, it's really up to the client.
Yeah.
You know, you've got to remember that. He just needs to understand what they both mean. But if I may say something.
Go ahead, Kev.
I just did.
You did? All right. Hey, I love you guys. I love you all. Thanks for attending. The class is officially over. We can stop the recording. If you want to hang out for a while and have a discussion, I'm happy to stick around.
And by the way, a lot of you asked about Lance's 1 hour class on earnest money. Will can get that set up with Lance. He'll be more than happy to do that. Maybe one of these Wednesdays, but we ought to do it pretty quick. He hasn't taught it for a while, so he's due to put that up, and y'all should attend it if you haven't done it.